It's Jen the Liberty Lion. Here's a new book, one that I just got called Mastering Legislation, Regulation, and Statutory Interpretation. I wanted to bring up a few points before I read this book. So, the first point is that in this book, she's talking to lawyers and attorneys. So, when I read this small section in here, you'll understand that she's expecting lawyers and attorneys to read this book, not necessarily regular citizens like us. There's a difference between vague laws and specific laws. Vague laws have to be interpreted. There's no other choice. You can't really administer a vague law, whereas very specific laws are just administered. In the first Judicial Act in the 1790s, the oath in it said that the judges and or justices, I don't recall if it uses both words or just one, it says that they will faithfully administer the laws of the Constitution and the United States. It doesn't anywhere in that act, so far as I've been able to find, say anything about interpreting laws. So that tells me that the laws are supposed to be specific. They're supposed to be written specific enough so that people can follow them. They'll know exactly what to do, what not to do, when to do, whatever. And the judges aren't left to interpret, they'll simply administer. And there's been arguments that I've read in other books where they talk about, and I read books from a lot of different people, they talk about the difference between what is vague and what's specific, and that if something is too specific, it's too rigid and it doesn't allow for things to happen. But where things are too vague, it allows too much to happen. And that if you make laws specific, not enough can happen. So they make them vague so that they can pull in situations and the people in those situations under some vague law, and they claim that that's the way that they can administer justice, by these vague laws. But vague laws leaves the citizen at a disadvantage because they don't always know and can't always tell what was actually supposed to be done or what was not supposed to be done. So then I would look at the military rules and regulations, and in no way am I suggesting that laws should be written in a military style and that regular people should have to follow laws as strictly as the military does. But what I'm saying is that a community can run smoothly if the laws are specific and not left up for interpretation. And that if we had fewer laws, then there would be no requirement for so many vague laws to be written so that they can basically capture people doing things and then bringing them into court, and then the person who's brought into court really had no idea they were doing anything wrong. I think it was Judge Napolitano that said Title 26, which is the IRS code, that it would take somebody like their entire lifetime to read at the regular average reading speed to read the whole IRS code, or like 40 years of their life or something like that. And so there's no way that anybody could actually know these laws. But if they wrote the laws specifically and wrote it for just simple things to keep society running smoothly, I think that would work. And that the reason why they don't write them more specific like they do for military people is not because they don't think society can run in a military way, and I'm not suggesting that it should be, but because they wouldn't be able to capture as many people. They wouldn't be able to increase their power, and they wouldn't be able to make all the money that they make. So when they write vague laws and one of the judges or justices interpret it, they always interpret it, or not always, but almost always interpret it in favor of more government power. And so vague laws have a motive, or the legislatures who write vague laws have a motive, which would be to make money and increase their power. So I'm going to read just a small portion of what she says. Hopefully it won't take me a long time to get back to where it was. I haven't finished the book yet. This was from 2020, by the way. I'm gonna have to go through it this way. I apologize. I had my pen in here and I took it out. Okay, so she says, I'm going to read this blue portion here. I hope you can see it. If not, I'm reading it word for word. Why law works well most of the time. How is obeying the law possible if laws are so unclear? Most citizens do not have the luxury of hiring lawyers to help them understand the language of the law, nor do they have the time to study interpretation in the detail you will be doing, speaking again to lawyers and attorneys. Yet these citizens are expected to know the law, whether they have read it or not, and conform their actions accordingly. How can ordinary citizens know whether their actions conform to legal requirements if a lawyer has to take 3 years of law school and read books like this one to learn how to understand laws? So, pretty good point. I would agree with her wholeheartedly, and I think that the laws are written vaguely, intentionally, and that the founders never intended that the Congress of the United States, or even any of the other legislatures, like the state legislatures, they never intended them to use their offices as a means to make government more powerful, or to act outside the Constitution or the laws that govern how the Constitution will be administered. That when they wrote the oath in the First Judicial Act, they actually meant what they said, and what they said was that the justices would administer the laws. We have interpretation, and we have various types of interpretation that I have another book on. The two basic types are textualism and intentionalism, what was originally intended, and then what's actually written in the law. So there are different types of textualism. I think they have something like, I don't remember them. Moderate is one of them. New is another one of them. And I forget the first one. It's basically a strict textualism, where they take it by the exact words on the paper. Moderate is where they take it sort of generally by the words, and this is textualism. And then new textualism, I think, is where they combine textualism with intention. So then they have also the history of the law and the policies that were set in place that helped create the law, so on and so forth. And so every judge might use a different means of getting to justice. So a judge might use new textualism, a judge might use the history of the law, another judge might use intentional, what was intended by the law. And so when you're following a law, you don't ever know what judge you might get and what they might decide to use. They could use any of them. So you would have to go and research not just how to get yourself out of trouble, but you have to research how a judge might, that once your case is assigned to a judge, you might have to go and research how this judge decides to read the law. I think I'd read somewhere Scalia and another Supreme Court justice had a knockdown, drag out fight on how some of the vehicle codes should be interpreted. These two judges, I guess, were fighting for years over the legality of the word, or the meaning of the word vehicle, and what did that include and what did it not include. And so one of them was sort of going after the idea of the intention of the law, and the other was going after the text of the law. I didn't read in detail on what the outcome of that was or anything, but so this is the book I have. This is the latest book that I'm reading. Linda Yellem. I don't know how you say her name. I don't know if she's French or what, but she is, I think, working at Ohio State right now. I emailed her. She did email me back. I asked her about the oath and how it says administer, and she gave me a bunch of stuff to read. I haven't finished reading all of it yet, but she talks about intentionalism, or not intentionally, she talks about interpretation by judges. So in my opinion, they can write the laws to be more specific, and they choose not to because it's more beneficial to government power and acquiring money or property, or even the appearance of being necessary to the citizens. And I think a lot of our problems with government could be avoided if they would write the laws to be more specific. And if there was a problem with that, perhaps they should write fewer laws.